Ladies and gentlemen of the jury, we now come to that part of the case when the court will charge you as to the law which applies in this case. At the outset, I believe it is again appropriate to explain to you the different functions which the court and the jury perform upon a trial of this kind. It is the duty of the court during the trial to pass upon the admissibility of all the evidence, to decide motions, and to declare to the jury the rules of law which shall guide them in determining the particular questions of fact which are herein involved. It is the duty of the jury to accept the rules of law as declared by the court, and to apply those rules of law in determining the questions of fact which are involved in the case. In brief, as to matters of law, you will have the law from the court as I give them to you. On the other hand, you, the jury, are the sole and exclusive judges of the facts. It is the duty of the jury to consider all the evidence in the case, to weigh it carefully, and to test the credibility to be given to a witness by his apparent intention to tell the truth, and by the accuracy of the memory of the witness, and in such a way to try and get at the truth, and to reach a verdict upon the evidence and under the rules of law which I shall give you. It is for you, the jury, to determine the inferences or conclusions, if any, which may properly be drawn from the facts, and you should not take the facts from the court, nor from counsel, nor should you decide the facts in any manner in which you may believe that the court or counsel would like to have them decided. Again, you are the sole and exclusive judges of the facts, and it is your exclusive jurisdiction to determine the facts, and it is also your responsibility to determine the facts. Also, you are the sole and exclusive judges of the credibility or the believability of the witnesses. In order to determine whether a certain testimony is believable, you should consider the interest of the witness, his or her motive to tell anything but the truth, his or her hostility or prejudice, if any, the backgrounds and the appearance of the witness on the witness stand, the manner in which the witness testified, and the opportunity which he or she had to observe and understand those matters concerning which his or her testimony is given, and whether or not the version of the witness is a reasonable and probable one. Now, it does not necessarily follow that an interested witness is not a truthful witness, nor that a disinterested witness is a truthful witness, but it is a matter for you to consider in determining what weight you should give to the testimony of such a witness. The number of witnesses is not important. The quality of their testimony is very important. You have the right to apply all the common sense and experience which you ordinarily apply in your daily life in determining whether or not a person is telling the truth. If you find from the evidence in this case that any witness has knowingly testified falsely to material facts, You have a right to reject all of the testimony of such a witness and to base your verdict upon the other evidence that remains in the case. Now, I do not say that you must disregard the evidence of a person who has testified falsely to a material fact. I say that the rule is that you may do so. It is within your discretion to accept or reject the testimony of such a witness. You can believe the testimony of any witness in whole or in part. You may reject part of it and accept part of it, or you may reject the whole of it. It is the duty of the jury to reconcile, if possible, conflicting evidence as to material facts, because experience has taught us that persons seeing the same events at the same time may not be able to describe the events in exactly the same way. If you cannot reconcile conflicting statements, you should reject that evidence which you do not believe and accept that evidence which you find to be credible. Now, the witnesses Catherine Calder and Lonnie Caruso were security personnel at the Day Brothers department store. Now, the fact that they are security personnel should not affect your judgment one way or the other, and should not make their testimony more or less believable. You should just judge their credibility on its own merits and in accordance with the same rules which are applicable to any of the other witnesses. Now, there are rules of law applicable to every criminal trial, which you must apply in determining the questions of fact involved in this case. I will define these rules of law to you, and it is your duty to apply them in endeavoring to reach a conclusion in this case. The defendant is presumed to be innocent until her guilt is proven beyond a reasonable doubt, not any doubt, but any reasonable doubt, and that presumption of innocence continues in favor of the defendant throughout the trial until her guilt is proven beyond a reasonable doubt. When the guilt of the defendant is proven, the presumption of innocence is overthrown. In order to find the defendant guilty, you must find that the evidence establishes beyond a reasonable doubt every element of the offense charged and the defendant's commission thereof. The defendant is not required to prove her innocence. The burden of proving her guilt rests upon the people or the prosecution, and the people must establish that guilt beyond a reasonable doubt. If the jury entertains a reasonable doubt as to the guilt or innocence of the defendant, they must acquit the defendant. If the jury can reconcile evidence in this case with any reasonable doubt which is consistent with the innocence of the defendant, it is their duty to do so, and in that case, the verdict must be not guilty.